And good morning, Ms. Burge. Would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes, Judge.
Thank you. Sir, are you Christian Lazo?
Yes.
And Mr. Lazo is charged with aggravated robbery in cause number 25 DCCR 1423, and that's from May 25th of 2025. And Mr. Lewis, it's my understanding that you need a reset to meet further with the Assistant District Attorney and work on the case. Is that correct?
That's correct, Judge. We've met with Mr. Lonzo, with Ms. Burge to go over the situation with him. There's definitely some additional investigation that needs to happen before we move forward.
Okay. Any issue with that, Mr. Nichols?
No, Your Honor.
Mr. Lazo, I'm going to reset your case so that you can meet with your attorney and then some more and discuss, and then we'll be back at a later date to get an announcement in your case.
Okay. Yes.
Thank you. Thank you, Ms. Burge. You can go back with the bailiff.
Thank you.
Sorry you had to wait. I'm so sorry.
Okay, Judge.
All right, so what is the announcement at this point?
So I spoke with counsel about step does. I haven't received a motion like what he explained to me
I emailed it.
Okay, when?
It was just recent. I know you were in trial.
Okay. I hadn't reviewed it, but he did explain to me what it was, and my understanding, Judge, is that he wants to get an order from the court, I believe, to take pictures and maybe video of the biological father in this particular case.
His home.
His home, not him.
Yeah.
Right. That's my understanding. Now, I explained to counsel, like, it's not gonna be the state gonna go back and do part of investigation if, an investigator on him would
No,
like to do it.
that's the request, and I know you haven't seen it, but the motion is for his investigator to go into that home.
Right.
Do you have any objection to that?
Your Honor, I think it's up to the court. He's not part of our investigation in any way. I understand if he may think that, that's an
If there's
avenue
any
they can go
potential, I think if there's any potential
Scope
evidence of exculpatory nature, then I would be,
There's no other way for us to get our
see.
hands on that, Your Honor.
So here's what I'll do.
The judge is basically green-lighting a controlled defense investigation. Photo/video only, no rummaging, no touching, no CSI cosplay. It's a careful balance. The defense gets a chance to look for potentially exculpatory evidence, and the state gets transparency by having their investigator present.
I'm going to grant the motion. Obviously, it is just for pictures and video.
Yes, sir.
It's not to open, move, dig through, look under, things like that. It's just a take pictures, not touching.
Yes, sir.
If there is something based on what's found then that you feel like you need further
Yes.
orders, or hey, we see something we want to get or get tested or whatever it may be, then come to the court and we can deal with that.
Yes, ma'am.
I would ask that your investigator get with the assistant district or the district attorney's investigator.
Sure.
And that their investigator be allowed to be there, so that, because he also would be, or she would be the person that would
No objection.
facilitate that.
No objection at all.
And get with the biological father, have your investigator get with them, get with his investigator, have them coordinate, the investigators coordinate when it can happen, and that your investigator can be there for that as well.
Yeah.
Maybe have the homeowner of that home explain the situation and have him sign off on some kind of a waiver. It just seems, he's gonna answer the front door and say, why do these people want to?
No, we're not gonna do it that way.
Just do it to your order.
I want your investigator or you to contact him, explain to him that I've allowed this, and explain to him the limited purpose for it. It's just for pictures or video, and that they'll coordinate a time. Your investigator's there to make it more comfortable, somebody he's talked to, then your investigator gets there. So we're not gonna have somebody go knock on the door.
Yes, sir.
Y'all have your investigator get in touch with him this week. Your investigator in touch with them, and
Yes,
y'all
sir.
get this taken care of within the next couple of weeks.
Yes, sir.
And our investigator judge is to be clear, to be present while
Yeah,
this is going on.
absolutely. I think that's to make I want it to happen that way so that the biological father is comfortable
Yes.
with somebody from the state being there as well.
Yes.
And so I think that's probably the cleaner way to do it, okay?
I agree.
So we'll get that done, and then what I'll do is just, is that all we're kind of, so we'll just reset the case then, for a normal reset, and, based on that, you guys take some time, please, between now and then, if there's any offers, make sure you extend an offer, so that, Mr. Salinas can review that with his client before that next court date, okay?
Thank you, Your Honor. I
Thank you.
appreciate it.
You can go back with the bailiff if you could let him know, and I'm gonna sign this order.
Thank you, Your Honor.
Good morning, are you Royal Gonzalez?
All right,
I'm sorry?
yes,
Okay. This is 25 DCCR 0226. Mr. Gonzalez is charged with burglary of a building. And I'm going to take judicial notice of the court's file. Mr. Gonzalez was previously found not competent to stand trial, was sent to a facility for competency restoration. I have received a report from the John Dunn Behavioral Science Center dated December 23rd of 2025 with the finding that Mr. Gonzalez is now currently competent to stand trial. Included in that is the report of competency prepared by Dr. Cassandra Hayes. And she also makes the finding that Mr. Gonzalez is currently now competent to stand trial. Let's see. In addition, I received from Dr. Madeline Gabe, a letter indicating medications and treatment that also took place. Her finding and opinion is also that Mr. Gonzalez is now competent to stand trial. Is there any other evidence with regard to competency?
No, Judge, nothing.
And so I will at this time, based on that information and those reports, find that Mr. Gonzalez is now competent to stand trial. What is the announcement?
Judge, I received a report, of course, during the holidays a couple weeks ago. I did go out and visit with Mr. Gonzalez to find that our communication was definitely a lot better than previously. I do need a little additional time. I've talked with the state about whether there's gonna be any new offers or anything, which he did convey an offer to me that I need to really sit down with Mr. Gonzalez.
Take some time. Let's just do a normal reset, Mr. Gonzalez. Mr. Lewis will be out there to see you again to go over everything, and then we'll find out what we're gonna do with your case at the next court date.
okay.
Okay, you can go back with the bailiff.
Maybe, you know.
Yeah. All right, are you Camden Jackson? And this is 24 DCCR 0114. Mr. Jackson has recently been, or more recently, been evaluated for competency to stand trial by Dr. Krapon. I've received that report and going to take judicial notice of the court's file. The report from Dr. Krapon is dated December 4th of 2025. He makes the finding in that report that Mr. Jackson is competent to stand trial. Is there any other evidence with regard to competency?
Just not to competency, but there is a concern that I've come to find out, of course, that the entire time Mr. Jackson has been in custody, he has not been on his medication and not been given his medication, and considering some of the medication he's on, I think it explains a lot with the acting out and things, with the issues you've been getting from jail.
Right.
So that's a big concern of mine, if we get him medicated and dialed in, so
Okay.
try to move forward.
So, what I'm gonna do then is make any other evidence with regard to competency.
No, not with regard to competency, Judge. I have reached out to that jailer, I know earlier, due to the proximity of this violation to his actually granted probation and his behavior in the jail. I did reach out to her. I think she works a different shift than all of us do. I think she's there all night, so I've had a hard time doing that, but I'm happy if the court needs to speak with her. I don't know that we have proceeded on that count one way or another yet.
Well, no, we haven't done anything because we've been doing competency evaluations. And so here's what I'm going to do.
This medication issue is a whole other layer. Someone can be found competent on paper, but if they're unmedicated in custody and spiraling, the case turns into a moving target. I actually respect what the judge does here. She's like, I'll call the jail, we're addressing meds and safety after docket.
I am going to make the finding based on that report that Mr. Jackson is competent. If you'll make a notation and put it on my desk, I'll contact the jail to find out what they need as far as having him evaluated through their medical staff for any medication. And then we'll see if that will help, and then we'll reset it.
And also, Judge, just, I don't know what kind of help you can provide in this regard, but some of the issues that he has had at the jail with the fighting or things of that nature, or where he may have initially been defending himself and aggressor or things of that nature, but it's a situation where he has asked to be isolated or move away from certain people, and that they've never done it. And so
There's only so many places for
I
all of
understand.
them is the problem, but I will talk to the jail about that
Right,
also.
but I understand the biggest issue with him, of course, is the medication.
Okay, I'll work on both of those things after docket. You can go back with the bailiff. All right, so are you Dakota Coon? And this is 23 DCCR 0968. Mr. Coon has a motion to revoke his probation, on probation for attempt to commit assault a family member by impeding breath or circulation. One of the or a couple of the allegations have to do, in that motion to revoke, with the possession of controlled substance out of Chambers County.
Right.
Mr. Lewis has informed me that they have at this point filed those charges and have them over there. And it's asking for a little bit of time to get with them, get all of that information so we can go forward. So I'm going to reset your case, give him a little bit of time to get everything figured out that he can, get with the district attorney, and then we'll figure out what we're going to do at the next court date. All right, you can go back with the bailiff. Michael Murillo. This is Mr. Hoffpowers. Good morning. Are you Michael Murillo?
Yes, ma'am.
And Mr. Murillo has 6 cases, cause numbers 25 DCCR 0377, charged with fraudulent use or possession of a credit or debit card. 25 DCCR 0378, burglary of a building. 25 DCCR 1078, burglary of a building. 25 DCCR 1079, burglary of a building. 25 DCCR 1516, burglary of a building. And 25 DCCR 1517, possession of a controlled substance. Mr. Lewis, what is the announcement?
Judge, this defendant here was one that I don't remember if he was previously on bond, but he entered a rehab facility and then turned himself in once he was released from there. Recently, we completed a program. I did reach out to Mr. Hoffmeyer about this, trying to get a resolution, see if we can come to some type of resolution. Mr. Nichols did give me an offer this morning in regards to that, and I talked to Mr. Murillo about it. We wanted to at least have the opportunity to go over some of that stuff from the facility and other things that he did while on bond with Mr. Hoffmeyer.
All right, so Mr. Murillo, I'm going to reset your case, just a normal reset, to give Mr. Lewis time to get all that information, get it to the assistant district attorney, and we'll get an announcement at the next court date. You can go back with the bailiff. Try. All right, are you D'Antonio Riggs? And Mr. Riggs is charged with aggravated robbery and cause number 25 DCCR 0975. We had Mr. Riggs evaluated for competency to stand trial. I'm going to take judicial notice of the court's file. It includes the report from Dr. Grapon, which is dated October of 2025. And I'm not sure if I haven't already made this finding. I feel like I would have had a court date since then, but it is and does have the finding in it that Mr. Riggs is competent to stand trial. Is there any other evidence with regard to competency?
Judge, just that I still have some concerns in regards to that matter, especially after speaking with his family on multiple occasions about their interactions with him. When I talked with him, it definitely gives me concerns about moving forward with how we proceed with this matter. I know he's been evaluated before. I would like for someone else to take a look, if that's possible.
Okay. So if you're still having trouble communicating and understanding, the only thing I can do is at this point have someone else take a look. A few months have passed since this was done. There is a history, it appears, with spinal top as well as hospitalizations at Fannin and in Houston. So obviously there's some history. So I will reset the case. We'll do an order and request an additional evaluation to see if anything's changed since that last one, since it was October, and we'll get Dr. Hamza to take a look at them and see where we are at that point.
Okay.
All right, you can go back with the bailiff.
Thank you, Your Honor.
Thank you. Good morning. Are you Joshua Smith? Mr. Smith, you're charged with fraudulent use or possession of identifying items 50 or more in cause number 25 DCCR 1439. And Mr. Lewis, what is the announcement?
Judge, after speaking with Mr. Smith and with my client, there is some questions in regards to his criminal history that I think we need to clear up.
Okay.
So I know exactly where we stand on this criminal history moving forward. I think that could affect what the offer or what we possibly on the counter could be looking at.
All right, so I'll just do one normal reset to give you some time to get all that taken care of. Mr. Smith, I'm sure Mr. Lewis will be out there to explain all of that to you. We'll get an announcement at the next court date. You can go back with the bailiff. Okay, all right, and so will Mr. Vincent waive the formal reading of the indictment?
He does, Judge.
And sir, are you Troy Vincent Jr.?
Yes, ma'am.
And Mr. Vincent, in cause number 25 DCCR 0384, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of evading arrest or detention with the use of a vehicle from February 11th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Vincent is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty in count 1 of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, sir. You can go back with the bailiff.
Thank you, Judge.
Thank you.
Yes, ma'am.
Good morning. Are you Trevon Alexander?
Yes, ma'am. Good morning, everyone.
Good. And Ms. Perazo, will your client waive the formal reading of the indictment?
He's later on. It's not for this.
Mr. Alexander, in cause number 25 DCCR 0831, you're charged with a first-degree felony offense of murder from May 13th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Perazzo?
Yes, ma'am.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am. She explained it.
Okay, good. And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Understood.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Alexander is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the first-degree felony offense of murder. Sentence you in accordance with your agreement to a term of 30 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also have handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Perazzo. All right, good luck to you, sir. You can go back with the bailiff. Good morning. You're Logan Eaglin?
Yes, ma'am.
Mr. Eaglin, in cause number 25, DCCR 0897, and we've gone over this before, but I'm going to go over it, make sure we're all on the same page and you understand everything. In that case, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that's from October 26th of 2024. Your indictment alleges that you were previously convicted of burglary of a habitation, March 1st of 2013, in 2 different cases of burglary habitation on that date. And then on September 3rd of 2015, you were also convicted of prohibited substance or possession of a prohibited substance in a correctional facility. What that means is if you go to trial and you're found guilty in this case, and those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on count 1 only, just the aggravated assault case, with a cap of 20 years as your punishment, which means you would be leaving your punishment up to me. I can give you 20 years, I can give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and have a jury decide your case. I just want to make sure you understand the possible consequences if you go to trial and what your options are. You understand all of that?
Yes, ma'am.
And you want to reject this and go forward with your trial, is that correct? All right, is there any evidence or discovery that hasn't been turned over that you guys are waiting on?
Not that I'm aware of, Your Honor.
So I will set it on the next available trial docket. Everybody will be prepared for trial, and we'll get your case tried as quickly as possible. You can go back with the bailiff. Good morning. Are you Marissa Fortune?
Good morning. Yes, ma'am.
And Ms. Fortune was previously in court, entered plea of guilty in cause number 25 DCCR 1117 to the new offense of credit or debit card abuse, and then entered pleas of true in cause number 24 DCCR 1156. It was a motion to revoke probation. And the agreement was for a 5-year deferred on the new case to continue her on probation, and in each of those cases for her to be ordered to enter and complete the cognitive track of the ISF program, correct?
That's correct.
In addition, there was restitution in the new case, but I don't
The
see
victim
an
himself,
amount.
it was a credit card.
$301.66.
It was a credit card.
When the judge says you likely won't get this opportunity again, that's courtroom code for this is the last exit before prison. Deferred probation deals like this are basically a contract. We'll hold the conviction back, but you have to do the work.
victim was not charged that stuff between the credit card company,
Okay,
if they were actually out. And I haven't heard anything from them.
you have not heard anything from the credit card company, then I'm not going to order it. That just makes it more confusing, I think. Have you heard anything or, okay, thank you, ma'am, and thank you for being here. All right, then, I have received that pre-sentence report, reviewed it, and the update. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes.
Any additions or corrections?
No, Your Honor.
Nothing, sir.
Okay, so Ms. Fortune, you're going to be given an opportunity today that you likely will not get again, okay? So I want you to take advantage of this. Everybody's willing to work with you, get you the help you need so that you can be successful on both of these probations. But I want to make sure you understand that if you're back in here on a motion to revoke on these cases, it is very likely that you will be found guilty in each of these cases, become a convicted felon, and end up in prison. Okay? Yes, ma'am. So I'm going to find in cause number 25 DCCR 1117 that you entered that plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but at this time I'm going to follow the agreement that you made and defer all proceedings and place you on probation for 5 years. You're ordered to follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. And then in cause number 24, DCCR 1156, I'm going to find sufficient evidence to revoke that probation, but I'm not going to do that. I'm going to continue you on that probation and modify the conditions of it to include that you enter and successfully complete the cognitive track of the ISF program. Again, you do all of this, you're going to be given the tools that you need to be successful. And if you don't take advantage of it, you won't be leaving me many choices. You understand? I'm going to hand you in each of your cases, excuse me, the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. All right, good luck to you, ma'am. You can go back with the bailiff.
Yes, sir.